Sorry about that. You can still hear me, right, Mike?
Yep, we're good.
All right, let's get started. Off to a great start in 2021 here. Hello, everybody. Good afternoon. This is Eric Hauge from Homeline, and you're joining us on Wednesday, January 6th. Oh, look, I forgot to change the date. 2021. It's not the first, not the last time that'll happen. Anyway, it is actually January 6th, 2021, and you're joining us here in the afternoon for our first COVID-19 tenant landlord law during the pandemic.
Just to be clear, we're in 2021 now.
We are, yes.
Okay.
We did not go back in time.
This is live. Yep.
And let's see here. We're joined by Mike Vra, Managing Attorney and Tenant Hotline Director at Homeline. And just a reminder about who we are and what we're doing. Homeline's a statewide organization, nonprofit. Our main program is a free and confidential legal hotline that any tenant in the state can contact and get advice specific to their situation for free. And we've advised over a 250,000 households since opening. And our services are available to folks in English, Spanish, Somali, and Hmong languages. We have been, there's our tenant hotline contact information, toll-free number, and then the specific language lines as well are up on your screen, and how you can contact us if you're a tenant over the internet as well. So we do cover general legal information in these seminars, these regular webinars about pandemic-related rental issues. But if you have a very specific question about your circumstances and your renter, please contact our hotline. So yeah, a reminder: we've been doing these webinars since April of last year, and and we intend to continue them on a fairly regular basis. There's a lot going on in January, so we are taking a few weeks off after today. Today's seminar will, of course, be recorded. We'll have plenty of, we'll have some time at the end for questions and answers. But then our next one will be scheduled a few weeks out on Wednesday, January 27th. Again, another 90-minute webinar, and we're going to be joined by landlord attorney Kim Tennyson, who actually joined us on a webinar. I think it was in the middle of the summer last year, to kind of bring that perspective of what landlord attorneys are seeing, how they're advising their clients, and just sort of what we're expecting to happen as we go forward. So that's later in January. That'll be after any decision is made here in Minnesota about the extension of our Minnesota eviction suspension, which will come to an end on the 13th of January, unless the governor and the legislature move it ahead. That's also sort of in line with the current end of the CDC moratorium, which was extended. And Mike will get into that more in a few. So again, that is on January 27th. I'll put a link to the registration in the chat in just a moment.
And just to interject a little bit about Kim, she has been watching a lot of these sessions and frequently comments and helps with very useful comments. And she is, I believe, our first second-time guest, right? First repeat guest that we've had, or she will be.
That might be right. Yeah.
Yeah. Okay.
So I'll put a link to the registration in the chat. We'll also get a follow-up email with those details. We also already have scheduled our first one in February too. It'll be 2 weeks out from that one. It'll be on the 10th of February, if I have that correct. And we're going to be joined by a couple legal aid attorneys that serve areas outside the metro area. And so we don't have everything finalized for that yet, but that'll be on February 10th. Another couple helpful and special guest speakers coming up. So that's for going into the future. So for today, I'm going to pass it over to Mike. Just a reminder, we did get a couple questions submitted in advance, but We're going to leave some time today to cover some questions at the end. So we have a few submitted, and we'll get to those later. But for now, Mike's going to go through kind of an update of where we're at.
Okay, thanks, Eric. All right. So what we're going to talk about today is a couple of the same topics we've been talking about since April, but there's new information on both of the key hurdles to filing an eviction in Minnesota currently, which is how we've always examined this question: when can a landlord file an eviction for non-payment of rent, which is well over 90% of evictions in Minnesota have historically been filed for non-payment of rent. And so that's the key question when it comes to landlord-tenant law. As I've been referring to it, it is the banner headline in landlord-tenant law in Minnesota and will be until it goes away, the eviction moratoria. I'm talking about a state one and federal moratoriums that have played roles at various times since the pandemic began. We're going to start by looking at the Minnesota moratorium. It is hurdle number one for any landlord that is thinking about filing an eviction for non-payment of rent. This is the first hurdle they have to be able to get past. And I'll explain why that is when we get to the federal ones. But suffice it to say, this is the one that landlords have to get past first if they want to be able to file an eviction for non-payment of rent in Minnesota right now. The governor's executive order about evictions, essentially banning non-payment of rent evictions, along with some other evictions as well, is tied in time to the Peacetime emergency declaration. Now, I know, I'm not sure if the Wednesday announcement has happened yet from the governor saying exactly what the modifications are to the Peacetime emergency. I understood there were going to be some changes in restaurants and bars and movie theaters and things like that that were going to be announced today. Maybe they already have. But those are tied to the Peacetime emergency as well. But the eviction moratorium is tied in time to the declaration and the ongoing declarations of peacetime emergencies from the governor. Those started way back in March when the pandemic was just showing up, and they have continued. The governor's renewed the peacetime emergency declaration 9 times since March. Each time, the legislature has a chance to end the peacetime emergency declaration, or I suppose they could vote to end the eviction moratorium as well. But probably the most direct way to end the peacetime emergency would be one of 3 things. It would be either the governor deciding not to renew the peacetime emergency declaration, which we haven't really seen any sort of signs from the governor that that's something that he's considering, ending the peacetime emergency. He seems to be content to modify things. As mentioned, the restaurant changed today, where I think it's going to 50% or 25% or whatever the number might be. Those kinds of dials that have been visible in the newsprint or social media or on TV that we've seen, where we see how far the governor has reopened certain things, has been useful in the governor's mind to react to the conditions as they're presenting themselves. How many people are in the hospital? How many fatalities have there been recently? How many known cases have been contracted of COVID-19 in recent days, weeks, or months? And that is tied, like I said, largely to the eviction moratoriums as well. The eviction moratorium hinges calendar-wise on the peacetime emergency. So again, the governor could decide to stop renewing the peacetime emergency. That would be one way that the ongoing peacetime emergency that we've had since March would end, as the governor just relinquishes that power, or I suppose they could just let it die. January 13th is the next end date of the current peacetime emergency declaration that we're in, and the governor could simply not issue another peacetime emergency declaration. The next way it could die, the peacetime emergency, and by attachment, the eviction moratorium, is if the legislature decides to end it as well. Now, there are 2 versions of the legislature sort of considering this: when the legislature is in session, which is now, or when they're not in session. They were not in session last spring. That's when they ended their last session, the 2020 session. And since then, whenever the governor was renewing the peacetime emergency declaration, so this was, June, July, August, all the way through December, at those times, the legislature was not in session. And so by statute, the peacetime emergency declaration statute, every time the governor issued another or a renewal of the peacetime emergency declaration, then the legislature was automatically sent back into a special session. Normally, special sessions are called only when the governor calls them. They're then ended whenever the legislature decides to end their special session. But because of the peacetime emergency declaration rule, the statute, by law, the legislature had to convene whenever the governor decided to extend the peacetime emergency. So we've seen throughout most of the year, I think except in November, there were votes on whether or not to continue the peacetime emergency declaration. So in order to strike this down legislatively, both chambers of the Minnesota legislature would have to say time to end the peacetime emergency declaration. The Senate, controlled by Republicans, has voted every time they've had a chance to vote to end the peacetime emergency declaration. The House, controlled by the DFL, Democrats, has voted not to end the peacetime emergency declaration. The governor, of course, is a Democrat as well. And so unless and until that ends, the House decides to end the peacetime emergency declaration, we're not going to see a legislative decision to end it. And the last way I think that the peacetime emergency could end is if a court decides to end it, decides that the governor has overstepped his authority under the statute. And we'll talk about a court case in a couple of slides here that directly address the eviction moratorium question in Minnesota. But to start, I want to spend a little time talking about where the legislature is here. So late December, there was an article in the Strib, and I don't have the exact quote here. This is a paraphrasing of it, but Speaker Melissa Hortman of the Minnesota House said that it would require 90 votes in the House to suspend their rules, the House rules, in order to vote on ending the emergency. I looked at the actual peacetime emergency statute. That's not in there. There's some House rules, and I didn't dig into the minutia of the House rules. I'm more or less taking the speaker at her word through the Strib, which I'm hoping the quote's accurate. But that's really what they were talking about is could the House decide to vote against the peacetime emergency declaration? Now, in sort of a bigger picture analysis, could there be a grand bargain at the state legislative level, probably involving the governor as well, deciding to end the eviction moratorium here in Minnesota? Maybe the peacetime emergency would go on. Hard to know what an agreement might look like, but the eviction moratorium would be agreed to be ended. Maybe the legislation that might be crafted would address the eviction during the pandemic situation. So taking away the unilateral power of the governor to decide what to do as far as extending the eviction moratorium. Is that possible? Sure. I think the legislature could draft a lot of things regarding COVID-19, and evictions are certainly one of them. It's a difficult thing to guess, and it's also difficult to think about when the legislature might actually meaningfully address this. And so what I mean by that is normal legislative sessions, at the beginning of each legislative session, there's legislation introduced, but the big, heavier parts of legislation that are proposed, debated, and ultimately decided upon seem to get decided at the end of the legislative session. And if not by then, sometimes they have a special session in June or whatever, because they couldn't quite reach an agreement because they didn't actually come to the negotiating table meaningfully until the very last minute. They simply ran out of time. This happens a lot more often than it really should. And this isn't a pandemic thing. This is just a kind of our state legislature, and I'm not sure how different that is from other states' legislatures. But my point about all this is the big, heavy, weighty decisions that the legislature tends to make tend to be made at the end of the session. And so that would be May that we're talking about. Again, this is completely speculation on my part. I know that Eric, who's I think muted right now, and I haven't talked about this at all, but we're all sort of fumbling around trying to figure out what the legislature might do, what the governor might be willing to do as part of a grand bargain. Maybe there's going to be money involved in this. In fact, go on to the next slide if you could, Eric. Yeah, trying to make this presentation as timely as possible. In the Strip this morning, there's a quote, and I'm going to read it directly. This again is referring to and quoting Minnesota House Speaker Melissa Hortman. She predicted they would change Walz's eviction moratorium to make it easier for landlords to remove problematic tenants. Now that the legislature is in session, it has more say over the use of federal COVID-19 stimulus funds. Hortman said Senate Republicans might not agree to distribute money for rental assistance unless Democrats agree to the landlord change. Now, this was built into a little longer conversation, but it shows that there's at least consideration of this issue at the state level. As part of this equation, I imagine that the federal involvement in the eviction moratorium will play a critical role. We'll talk about the CDC's ban on evictions in a second, but let's say that theoretically, the federal government decided to extend the CDC ban on evictions through the whole calendar year. Just went, you know what, said we're going to do the paperwork once. All of 2021, no evictions will be filed. Let's say they decided to do that. I think that would give the state a lot less motivation to keep the state eviction moratorium in place, frankly. And I don't envision the CDC making some sort of 12-month declaration on eviction moratoriums, but you never know. It's been really virtually impossible to predict everything that would have been done up until now, legislatively, executive order-wise, court decisions. I mean, we're all in uncharted territories in most parts of our lives these days. And I suppose it's no surprise that the eviction world or landlord-tenant law world would be somehow immune from the uncertainty that we're all facing in many parts of our lives. You know, is the kid going to have school this week or next week in person? Those kinds of questions. Is the restaurant going to be open? Can somebody go to the church that they want to? A lot of maybes, a lot of what ifs that many of us have been dealing with since this all began, and landlord-tenant law is no exception. As I've understood the governor's goal, both in the actions that the governor's taken along with executive orders they've issued and what the governor has said in the media, I think the governor's trying to react to things as the information comes in, as near as I can tell. All you have to do is look at the comment section of anything on Twitter or comments in the newspaper online to see what people think about what the governor's doing. Some people think the governor's standing up and doing everything a governor should do. Others think that the governor is overreaching completely and that this is just government invasion of private business. Some people think the governor isn't doing enough, that we should not be reopening restaurants and bars right now, that they should be closed down until the pandemic is more effectively snuffed out or the vaccines are more readily available than they are right now, or the higher percentage of vaccinations occur. But trying to predict at the state level what will be agreed to is hard to do right now. And predicting when they might take action might be just as hard. Although, like I said, most important legislation in this state historically has happened near the end of the legislative session. So who knows what kind of grand bargain might be reached. I assume that if there is legislation that is actually kicked around meaningfully, that means that more parties will have a chance to offer meaningful impact and insight into whether they think the proposed new statute is good. Does it go far enough? Does it go too far? Whatever questions might have, I assume that landlord advocates, tenant advocates would have a chance to chime in and say what needs to be changed in a statute or proposed statute or not. And then it'll depend on what can be agreed to by both sides. So is it possible that the state legislature would figure out a way to end the eviction moratorium and or the peacetime emergency? I don't think that they have to end the peacetime emergency to end the eviction moratorium. I think there could be a deal legally. I don't know why they couldn't. But again, it's probably going to need to involve the governor on some level. It's just hard to see how the House votes would be ample enough to decide to yank away the governor's executive peacetime emergency powers. Nor do I know, let's say there was a legislative deal put in place tomorrow, agreed to by the state House, the state Senate, and the governor. And it had a statute prescribing what would happen with evictions going forward. And they just said, here's the law, everybody agreed on it. But then the COVID cases ramp up, 10 times worse than they are today. Could the governor declare another peacetime emergency? I'm not sure why the governor couldn't. I suppose there could be a legislative change in the peacetime emergency statute. That could always happen. Or it could be part of the agreement, I suppose. I don't know. Obviously, very speculative stuff. But the benefit that the governor has had with the unilateral power is to make quick decisions. And a lot of these decisions have been made quickly, sometimes without notice at all, sometimes with a week's notice or a couple days notice. But we'll have to wait and see. And I know how unsatisfying that answer is for a lot of people who are trying to plan a tenant that's trying to figure out how long they know that they have a place to live if they're not able to pay all or some of the rent. How hard it is for a landlord to plan on their bottom line. If they can't be certain that the rent's coming in, they're not allowed to file an eviction for non-payment of rent because it's just not allowed. So I get the uncertainty and how difficult that is for everybody trying to figure out how to plan. But this is the system that we've got. And honestly, it's one of the reasons why we have been doing these speeches since April, is so we can try to make sure that people are at least informed about what the rules that we have currently in place actually mean. And so that's what we're trying to do. That being said, let's talk about the court case, the court challenge to the eviction moratorium in Minnesota. So this is important. This is the highest level kind of court challenge we have seen so far, challenging the governor's right to have this eviction moratorium in place in Minnesota. So there was a case, and we've talked about this before. This is the first time we've had the decision in front of us, though, for one of our presentations. This case was filed in federal district court. So did the case have to be filed in federal court, or could it have been filed in state court is a fair question. And it's, in fact, one of the things that the judge did note briefly in the decision, trying to figure out whether or not this should be appropriately heard in a state or federal court. I'm sure that there's arguments either way. I don't know if the lawyers that were involved in filing this case on behalf of landlords just decided that federal court was the only place this should be, or thought it's a close call and we want to go to the court that we think is more likely to be favorable to us. I'm not sure. But when this case was filed initially, I thought it was odd that it was filed in federal court. I thought state court was the proper forum for it. But anyhow, there are reasons why people would go to federal court. The decision was issued by a judge. I'm not sure how to say her last name, so I'll do my best. Brazel. As it seems required these days, although I don't necessarily like this concept, but it seems almost necessary to look up and see who appointed this judge, because it seems to give more credibility from a certain perspective, depending on who has appointed the judge. I don't think it should, but it seems to. So Judge Brazel was a Trump appointee a couple years ago. I had to look her up online and found her, and yes, appointed by Trump in 2018. And she ruled pretty strongly against the landlords, frankly. The landlords had quite a few arguments, and looking at a few of these cases around the country, whether they're challenging a CDC moratorium or other state moratoriums on evictions, there's sort of a usual list of legal theories that landlords or landlord groups are putting forward when they're challenging these types of moratoria. The ones that we hear seemingly every time are the contracts clause found in the US Constitution. So some amendments found in the Bill of Rights, the First Amendment, the Fifth Amendment, which is about takings. Eminent domain sometimes is part of that. The 14th Amendment, due process. These are where we find most of the arguments that we tend to see again and again and again. So when judges are writing decisions saying why the state, whether it's the federal government or a state government, so sort of the large state version there, it all seems to emanate from a concept of, hey, we're in a pandemic and we've got to give decision makers, policy makers, whether that's a governor or a legislature or a president, some discretion to try to address this pandemic. And they seem to be doing what they can to find the legitimate reasons to justify government in many years would be complete overreach Societally, that's how we view it. But because of the pandemic, the courts seem to be looking for, okay, how can the government justify what they're doing? Can they find enough constitutional ground or procedural ground to continue to do what they're doing? And so, as mentioned, the judge ruled against the landlords here, found in favor of Governor Walz and Minnesota in continuing with the eviction moratorium. And there were a few key points that the judge seemed to rest her decision on. And I wanted to touch on these. Look, this is like a 43-page decision. So unless you really want to dig in and read it for yourself, which you're welcome to do, I'm trying to give you some of the key highlights that the judge points out. And a couple ones that the judge mentioned that I thought really mattered was, first of all, this is not a permanent taking, sort of going to that eminent domain Fifth Amendment argument that landlords are making. The state's not taking this property from landlords. The state is temporarily stopping a landlord from being able to file an eviction. Now, you can argue that rent is the property of the landlord, or is their expected property, anticipated property. But the fact that the eviction is only delayed seems to matter a lot to the judge. The governor's order doesn't say evictions can never be filed. It says they can't be filed during the peacetime emergency. So it doesn't foreclose the landlord's possibility or right to eventually file an eviction. And another thing, the last bullet point here, is that the landlord can currently still sue for money. As we talked about before, an eviction is simply a case designed to figure out who has the right to possess the rental unit. That's the only real purpose that our, pardon me, our modern eviction statute really tries to answer. That's the question. Who has the right to possess the property? A landlord still has the power and the right to sue in small claims court, conciliation court, or district court for unpaid rent. What they're not allowed to do currently, if the rent hasn't been paid, is file an eviction for non-payment of rent, trying to regain possession. They're different, honestly, they're different courts for different purposes. And this seemed to matter to Judge Brazel that the landlord had the right to sue for money currently without possession. And so that was a factor. Additionally, she pointed to the exceptions listed in the executive order. As I've talked about before, if you want to look up one of these executive orders, you can go online. They're very easy to find. You just Google up, Minnesota governor executive orders. And how you read this is EO, executive order, 20, that's 2020 is what it's referring to, and then 79. I don't know if the governor has issued an order today. I assume that it's going to be EO 21-01 because we're in now 2021 now. So if there's a new order issued, it should restart and be EO 21-01, if I'm reading the executive order mapping correctly. To be fair, I never looked at an executive order, I don't think, until March of this year, like many people. But I'm pretty sure that that's how it's supposed to be referred to if there's a new order this year. So anyhow, that's the court case. This is in federal district court. Could the landlord appeal this case? Of course, they can go to the Federal Court of Appeals. I've never done a Federal Court of Appeals case. I've never done a federal case at all. Most of the landlord tenant work that we do is very state specific. But as I understand it, they file a case in the Court of Appeals. The Court of Appeals will hear the case. Doesn't mean that the landlords will win. If the landlords or the state doesn't like that decision, it can be appealed to the US Supreme Court, which has the discretion to say yes or no on every case, whether they even want to hear the case. And so I'm not sure if the landlords are going to file an appeal here. I'm not sure how much it's worth their time to file an appeal here. With the new president coming into office later this month, the CDC order might get extended beyond what it is already. And so the net effect of fighting the state's ability to enforce this eviction moratorium might have minimal importance. We certainly saw a lessening of pressure from landlords, I think on state legislators, from what we've heard, but also just sort of how our clients were relating information to us. Again, we're just a tenant hotline. We only talk to renters other than experiences like this where we hear from landlords. But the federal government's intervention through the CDC, banning evictions through the end of January and now through the end of January, through the end of December and then extended another month to the end of January, has seemed to lessen the, hey, the governor is the one person deciding all of this. The governor really isn't deciding all of this. If the governor stopped the eviction moratorium right now, we'd still have the federal ban on evictions in place. So we're still talking through all these first 3 slides about hurdle number 1 that a landlord has to get past in order to be able to file an eviction for non-payment of rent in Minnesota. And so there's more hurdles to come, and let's go ahead and talk about those. So the first federal hurdle that I'll talk about is found in the CARES Act. So the CARES Act is largely a memory now for most reasons that we care about. It was the legislation passed in March of last year that stopped evictions for non-payment of rent in CARES Act covered buildings through the end of July 25th, actually. There was a lot of other parts to the CARES Act. That's where the first giant infusion of federal dollars came from. I think it was the $1,200 checks that a lot of people got sent to them, just showed up in their account one day, or they got a check for it. And unemployment was extended and heightened as well. But it had some specific information about housing evictions specifically. And it said that in a CARES Act covered building, that a landlord couldn't file an eviction for non-payment of rent through the end of July. And once July 25th rolled around, if the landlord wanted to file an eviction then for non-payment of rent, they would have to give a 30-day notice telling the tenant that they were going to file an eviction for non-payment of rent. The ban on evictions sunsetted, as they say in legislative ease, on July 25th, as mentioned. But the 30-day notice requirement didn't sunset. So if the state moratorium went away today, and let's say the CDC moratorium, which I'll talk about more in a second, went away today, a landlord still might have to give 30 days notice in a CARES Act covered building in Minnesota. So what is a CARES Act covered building? Well, first of all, if there's any kind of federal subsidy involved in the building, there's chances are that it's CARES Act covered. The very broad definition used in the CARES Act legislation language referred to VAWA, the Violence Against Women Act, and it said that if it's a VAWA covered building, then it's a CARES Act covered building. Also, if the landlord has a federally backed mortgage, like through Fannie Mae or Freddie Mac, then their building is covered by the CARES Act. A lot of landlords in Minnesota would be covered by the CARES Act, but there's not really a public way to learn that. And so if the state moratorium went away, the CDC moratorium went away, and we're only left with the CARES Act moratorium, what we've seen other states that have been allowing evictions to occur since the pandemic began is that the landlord would have to give a sworn statement that they are not covered by the CARES Act, or they've given the 30-day notice as required by the CARES Act. But that's hurdle number 2. Now, it's the smallest hurdle of the 3 that we're talking about, because a landlord can overcome it. Either they're not covered by the CARES Act, or they give their 30-day notice, and then they've complied. But that's the second hurdle that a landlord has to get past. Let's move on to hurdle number 3, which is a bigger hurdle for sure for a landlord that wants to file a non-payment of rent eviction. Okay, so we're talking about the CDC order. All right, to refresh our memories, this happened in September of last year, and it was pretty broad. It banned all evictions for non-payment of rent throughout the United States, more or less. And it was a declaration from the executive branch through the CDC. So this is President Trump's doing unilaterally. And it said that an eviction couldn't be filed for non-payment of rent through the end of December. That has been extended as part of the bargain that was reached legislatively, both at the federal House and federal Senate, and then eventually signed by the president. I think it was a couple days before New Year's Eve. And it extended the eviction moratorium another month. Now, that wasn't the key part of that legislation. Again, money really was. I know we've all seen the argument where people were getting $600 checks, and the president at the last minute said, no, those checks should be $2,000. That is the same bill that had this eviction moratorium extension built into it. And so the president did sign it, so it's the law. And it does extend the eviction moratorium through the end of January. Now, the rent is still due under the CDC order, and it's still due under the eviction moratorium in Minnesota, the governor's executive order. There's no rent holiday, there's no rent cancellation. When this all began in March, we were not flooded, but we had a lot of calls from tenants that wondered about how to go on rent strike. How do they, force the landlord to give up their rights to rent? And what we told them then, and we are still telling them, is there's not any law that's canceled the rent. Nothing has done that. The rent is still due. Most tenants are still paying their rent. Are all of them? No, not all of them, but most still are. Late fees, a question that we've been getting since this all began. I've talked about 3 hurdles: the state eviction moratorium, the CDC moratorium on evictions, and the CARES Act. The CARES Act, which ended July 25th, mostly, is the only one of those 3 that stopped late fees from being assessed. The CDC moratorium does not stop late fees. The state executive order does not stop late fees from being assessed. So late fees are allowed, and they have been through all those hurdles since July 25th. The CDC moratorium really only matters in states where there's no eviction moratorium. And reading the Heights versus Walls decision, the judge did mention that the state moratorium was the moratorium that mattered, kind of an explicit judicial declaration, the most official one I've seen. It wasn't exactly the central part of the case, but the judge did say that. Anyhow, the CDC moratorium really has an impact in states where there's no eviction moratorium, where it's a really watered down one. Minnesota at present, and since the governor instituted the eviction moratorium in March, has had a stronger eviction moratorium in place for most purposes than the CDC moratorium that we have already. So again, we have the changing of the guard politically. Eric and I might be the only people right now that don't have that on in some part of our screen, or maybe Eric does have it on. I'm not sure what's going on in Washington with the Senate and the House trying to figure out how to count the electoral ballots, or however they're phrasing it. But I think most people agree that we're going to have a new president on January 20th. And when that occurs, what's going to happen with the CDC order is really difficult to know. I think unless and until there's a court that says that the federal government can't continue to do what President Trump's administration did for the last 4 months of 2020, where they had the CDC moratorium in place, unless a court says otherwise, a pretty high up court says otherwise, that's going to remain in effect until they decide at the federal level to take it away. I think we're hearing rumblings already that the Biden administration will extend the CDC order beyond what the January 31 deadline was. My hunch is that when this law was passed at the federal level, the one that extended the CDC moratorium another month, in mind with that 1 month extension was, hey, we're gonna have a new administration and we should let them make whatever decisions they're gonna make once they're in control. So I think that's a legitimate way to go about that for the legislature, and the President Biden will have a decision to make on whether to extend this. I will say that right now, for this 1 month period, I think at least one of the sort of constitutional arguments a landlord might have saying the CDC eviction moratorium is illegal. The version we have for just January of this year, at least so far, is one that's been approved by the legislature too. It's not just an executive order anymore, although its origin story is from an executive order routed through the CDC. It has been legislatively agreed upon for this 1 month, this eviction moratorium extension. So a landlord saying, hey, wait a second, a president shouldn't have the power to simply ban evictions. A counter to that today would be, well, the president didn't decide that alone. This was decided, the January version, by the president and the legislative body, the US Senate and the US House. So in my mind, it has more sort of conceptual heft to it right now. There's more backing. There's legislative backing here. It's not just the president making some sort of declaration and saying, this is what my rule is going to be, and you've all got to accept it no matter what. Okay, I think that is what I wanted to cover, and I apologize in retrospect for going so long on that. But it was two new issues that we're talking about: the CDC extension, that's new information, and the state moratorium being heard by a judge, and the judge deciding that that was legal, the state moratorium on eviction. So those are the two takeaways from me yammering for 40 straight minutes.
Thanks, Mike. Sorry, I didn't interrupt you too much there because you were on a roll. And yes, I am tuned into the Washington Post right now, as I'm sure other people are, because there's excitement happening. Before we get into questions, I'll just mention one thing, because I have actually gotten some recent information on this, and that is you did mention earlier in the conversation about the new federal law that has been passed that extends the CDC extension until the end of January, as well as providing a substantial pot of funding for rental assistance. So Minnesota is set to receive $375 million from that is dedicated for rental assistance. It actually is pretty specific. I don't think you can go to homeowners. It's very specific about rental assistance, and it's going to be parceled out in part to the state, so likely through the Minnesota Housing Finance Agency, who administered the CHAP program, the COVID-19 Housing Assistance Program that was enacted on the state level using CARES Act money last year and lasted through mid-December. But there's a little bit of a gap right now. So, that program had to end on December 7th. And there's been a gap. They've still been getting the money out the door on that program. So tenants are still getting their rent paid. Landlords are getting rent paid through that program. But there's a gap right now where people basically cannot apply. There's some county-based funds. We're referring to as many places as there is available. But there's a little bit of a gap between when that program ended and when these federal dollars will go out. Again, a portion of that, most of it, I think the majority of it goes to the state, and then some of the funding for the rental assistance is actually parceled out to some of the larger local entities like Hennepin, Ramsey, Minneapolis, St. Paul, and the expectation is that that the legislature has to approve this to come in. So that's what some of the comments that Speaker Hortman mentioned yesterday, is that that there needs to be this agreement for the legislature to accept the rental assistance, which it seems like a no-brainer to be accepting $375 million of federal rent assistance aid, but there may be a dynamic there. And then the second thing I think that's important, again, is that there is a delay. At the soonest that the state's going to get some of this money is by the end of the month, and it's still going to take considerable time to ramp that program up and have it work for tenants and landlords. So, but I think it's important to know that it is in the works, and for the time being, we have an eviction suspension, both on a state and a federal basis, and hopefully that stays in effect until these dollars are able to go out the door a little bit more efficiently. So with that, I'll transition over to our questions that got submitted in advance, just a couple that were submitted in advance, and then we'll get to your questions that have come in throughout the webinar so far, and any more that people have. So Barbara sent a question in advance. Any thoughts about tenant rights to have guests who won't follow all protocols, appointments, essential visitors, etc.?
Yeah, fair question, Barbara, and one that we get, and I know that landlords are upset about this as well, but we definitely hear this question from tenants complaining about their neighbors that aren't following the protocols that exist out there. To start, a tenant can complain to the Attorney General's office about this and ask that they enforce the mask mandate that's in place, which sometimes means that the Attorney General puts pressure on the landlord to put up more signage if they don't have the signage up that they're supposed to have, help enforce it. The Attorney General can try to enforce this as well. I suppose a tenant in theory could file a court case called a rent escrow about this, saying, hey, the landlord isn't doing enough to help solve the problem. The problem that a tenant has when they're dealing with a neighbor issue in general is that they don't have a contract with their neighbor. Tenant 1, who's upset about tenant 2, never signed a lease with tenant 2. They signed a lease, both of them, probably with the landlord. So it has to sort of get routed legally. It's the best way I can describe it. It has to get routed legally through the landlord if the tenant tenant one wants to, somehow hold tenant two accountable for their behavior. And a lot of because we get calls from tenants asking us about this issue. Hey, I have this neighbor that's not following the COVID rules or other problems with a neighbor. And the first thing that we always ask a tenant in that situation is, what is it that you really want? Do you want the neighbor's behavior to modify, to change, or do you want out of your lease? It's actually a lot easier in that situation from a, how do I accomplish what I want, if the tenant simply wants out of their lease. They can ask the landlord to go, and sometimes that can be negotiated. I mean, most leases that end early, there's a negotiated deal between the landlord and the tenant of some type. But if that doesn't work, the tenant who's upset could file a court case called a rent escrow, which is low cost. It costs about $70, the same price as small claims court. No attorney necessary in general. And it's pretty quick. It usually gets heard within a month, although depends where you're at in the state, how quickly a court's going to be able to hear a case right now. But probably the easiest solution for a judge to grant in a rent escrow where somebody's complaining about neighbor behavior is if the upset tenant really does just want to get out of their lease early. And because the judge is going to have limited power over that neighboring tenant as well. The most a landlord could typically do would be to file an eviction against them. Although right now that might be difficult, if not impossible, depending on the facts. So it's a case-by-case kind of thing, Barbara. We're happy to talk to a tenant about that. You can email us, and you've got the information on how to email an attorney directly or call our free tenant hotline. Both services are free. And we could try to walk through some of the details, but that's the sort of the general answer.
Right. Anonymous question. What is the best way for people to tell the legislature to keep the eviction moratorium?
I think I'll let you get this one, Eric. That's more in your line of job description than me.
Sure. I think there's a number of avenues. I think what we've found is useful, working with some community partners that have been instrumental in both part of the CHAP program and as well as just advising and representing tenants in these situations is to make that known to your legislators. And so, I mean, you can look up, and I can put in the chat the link to where you can look up who your state legislators are, both your state rep and your state senator. I think relaying the message to them directly is important, particularly if they're in a rural area. We have heard quite a bit of conversation just about sort of the dynamic of that renter population is more dense in the city, in the metro area, and so that's really the only folks that are impacted by this, and that's actually sort of the exact opposite to a certain extent. We're actually seeing more cases eviction cases filed right now during the pandemic that are being attempted to be filed under the exceptions to Executive Order 20-79 in outside of Hennepin and Ramsey County. So there's actually, normally it is the case that there's more evictions, particularly for non-payment of rent in the normal year in the two main counties in the 7-county metro area. But right now we're seeing more cases, majority of cases being filed outside of the metro area. So that's the step one, I would say, is look up your legislators, relay that message that it's something that, and it depends on where you're coming from. If you're a tenant, I mean, talk about how that's impacting you as a renter and how it's protected you and helped you to be able to access rental assistance during a period when you lost a job or whatever, however that has worked, and that it's still needed going into the future until there's an end to the pandemic and there's enough rental assistance in the pipeline to protect folks from displacement. If you're a service provider, that's, you can make that comment yourself to your legislators. You can encourage folks that you serve to relay those messages. Did you want to jump in, Mike?
Yeah. One of the questions that we frequently get when somebody says is, how do I get a law changed or how do I have an impact on the law, is you have to figure out what level of government you're aiming for. Here, you mentioned legislators. I don't think it's just state legislators that I would be talking to, nor do I think it would just be members of the legislative branch. I would contact the governor. I guarantee you there's landlords that contact the governor saying, here's what we want, and sometimes really loudly right now. I think the governor would be happy to hear from tenants as well, saying, hey, this has made a huge difference. There was 2 months where I couldn't make the rent on time last year, and that moratorium meant I got to keep my home. Does a tenant have to do that? No, but if they want to contact a legislator, I would contact the governor as well. Plus, there's the federal level too. Your state senators, your state representative that are serving in Washington. So Senator Klobuchar, Senator Smith, and whoever your House member might be, along with a note to President Biden or President Trump, however you want to do it. But I think it's worth doing at the federal level as well. As I mentioned, directly to the governor of Minnesota, because the governor has an outsized level of impact here when it comes to this peacetime emergency declaration. The governor sort of decides everything unless the legislature takes it away. So I would not limit it to just my state legislator.
Yeah, and the tool that I just sent in the chat, hopefully, yeah, I just sent it to the, that lets you put in an address, and it'll actually give you in order your House member, your Minnesota House member first, your Minnesota Senator, then it'll give you your U.S. House member, and then it'll give you both of your U.S. senators. So that's Klobuchar and Smith for everybody here in Minnesota. But I agree, contacting all levels is a good idea. And the phone number to the governor's office, I'll put in the chat as well. And
I really do think it matters to address the executive branch more than most times, both the governor and the president, about the impact that the eviction moratorium has had on you and how you need it, or whatever you want to comment on it. They have, like I said, an outsized role because they're allowed to issue executive orders that don't need legislative authority. So I'd contact them too.
Sure. And I mean, the last point I'll make on this is just, I think it is really, contacting them and saying that you support, the ongoing suspension is important. But I think also sharing and try to be brief about it, because they get a lot of calls. But I think sharing like a personal experience about exactly why it is that this has been helpful for you or your clients or whomever, family member or friend, that really is helpful for them to understand sort of the context for how this impacts them. Because there's a lot of state legislators out there that, probably many of them have been renters in the past, but there's not a heck of a lot of current renters. Some of them rent because they simply have to have a place near the Capitol, but they're not. Many of them are not in the same in the same sort of circumstances that low-income renters might be facing during the pandemic. So.
Yeah. Let me jump in for a second. I noticed that you're shifting around some questions, but 2 ways to get us questions. The one that we prefer is that you send it in through the Q&A. We tend to use the chat box for when Eric is posting links to things. So we'll typically move those out, and we'll still get to the question, hopefully. The best way to get us a question right now is through the Q&A. We have over half an hour and, I don't know, 5-6 questions lined up in the queue. And we'll get to all those. But if you have another question, I'm sure we'll be able to squeeze it in. So that's the best place to put it, but hopefully you can.
Okay, so we'll jump to the ones that have come in. Question from Roger. What about the problem of accidental tenants as outlined in the latest issue of Bench and Bar? Seems outrageous. Yeah,
so Roger asked a question referring to a specific article. I saw it for the first time this morning. I'm not sure when it was released exactly. But and I skimmed it. I was getting ready for the rest of the speech and reading a lot of different other things this morning. So basically, it was a landlord that didn't want to be a landlord. She was her family member had come to stay with her, didn't pay any rent, but was helping out around the house. There was sort of an informal agreement for her and her family to do things around the house, and then it's turned into a nightmare for the owner of the property. She wants to get her family out and apparently can't get her family out based on the eviction moratorium, at least was the theory of the article. It didn't strike me as being that clear cut that a landlord would lose that case, Roger. They could argue the family member exception in theory, which is one of the exceptions built into 20-79, although it's a little more complicated if the landlord is already in possession of some part of the house. But there are going to be sympathetic cases for landlords. There's no question about it. The day that this got all started, when eviction moratoriums were issued at the state level, and then they came at the federal level, there have been stories from landlords saying, I'm going to go out of business because I can't afford to make the mortgage payment. I can't make the necessary repairs that tenants need to make if my tenants aren't paying the rent. I don't think there's anybody that's saying that landlords aren't getting hit by this. It's a question of how to move forward. And I think there've been a couple thoughts sort of built into everything that's happened. Number one of the things we've tried to stop as much as possible is mobility of people. So I don't know any numbers on this, but I have to assume that the turnover rate in rental units in Minnesota in 2020 was much lower than in 2019. I've read all kinds of, landlord trade estimates and books like that. 1 out of every 2 or 3 rental units on average turns over each year. That's normally how it works. 1 out of every 2 or 3 turns over every year. And because of the moratoriums, I have to assume that more people have stuck around in their place longer than they wanted to. Landlords aren't really interested in chasing them out, and they can't necessarily chase them out when they might have been able to before. And tenants are probably a little less mobile. Some tenants have moved back home. Some tenants have moved with family. So there's been some moving around, but tenants just going from place to place to place to place is probably minimized in 2020. And again, landlords have been affected by this bottom line wise, and it's a little bit surprising to me that what Eric mentioned right after I stopped talking, my big giant chunk of time there, which is that the federal money might be held up in order to end the eviction moratorium in Minnesota. That is what you said, that you were more or less connecting all the dots about what Speaker Hortman was quoted as saying. Is that right, Eric?
Yeah, my understanding is that there has to be some sort of approval by both chambers
to accept the money,
to accept and begin using the
right.
Yeah.
And so I get that let's say the landlords, I know this isn't how it works, but let's say the landlords are just in charge of the Minnesota Senate. They're not. I mean, those are Republicans and they're not all landlord sympathetic. Some of them are, many of them are probably. But let's say that they all are landlords for a second. Would they say, okay, we're not going to get access to that $375 million that ultimately is going to get funneled to us unless we get the eviction moratorium lifted? Or would they say, let's get that $375 million? That's a lot of money that can be distributed throughout the state. And so it's a little bit perplexing to me that landlords, if they are somehow influencing that decision-making at the Senate level, would be willing to potentially forego, even for only a short amount of time, access to that money, demanding an eviction moratorium removal, which might not even be relevant if the CDC moratorium continues on. Again, we're trying to predict a lot of different moving parts here. And honestly, the speech that I put together for today, yesterday, was stale as of this morning. There was some stuff that I had to add to it because it wasn't current anymore. So it's really hard to keep up with this. But I get Roger's point that there are very sympathetic situations for landlords. There's no question about it. And there's very sympathetic situations for tenants as well. And we're all trying to figure out how to get through this.
All right. Next question, clarification, please. Leases state 8% late fee and all payments get applied to oldest balance. If there are unpaid rent or pet fees, water unpaid from prior month, the new payment will go to that first and late fee can be applied to new unpaid balance?
A landlord can try that. I wouldn't want to make that argument in court necessarily. In looking at the late fees statute, which whenever I give one of these presentations, by the way, I actually have the Minnesota statutes pulled up in front of me so I can look them over. And I saw this question earlier and I had a quick glance at it. And I know we've had questions about late fees in the past before. In my mind, first of all, this is not really a COVID-19 specific question. It's a landlord tenant law question, which I certainly don't mind answering in these sessions. Happy to answer whatever kinds of landlord tenant legal questions you might have. But anyhow, the late fee statute, which is, if you want to look it up yourself, and you're welcome to, you can find it in the chapter 504B. That's where all Minnesota landlord tenant chapters are these days, 504B.177. That's the late fee statute. And the key part of it says, in my mind, to this question, in no case may the late fee exceed 8% of the overdue rent payment. So, all right. Here, the questioner saying, all right, so there's some unpaid rent or pet fees, water, from prior months. First of all, I think the landlord can only get a late fee once per due amount. So if I don't pay my rent in December and the late fee gets tacked on, and let's just use $1,000 for rent, so it'd be $80 for a late fee. Then come January, I don't get billed for being late again if I make everything, if I pay January's rent on time, but I haven't paid December's rent. Do I owe the 8% for December anymore? No, you don't. You owe it one time. It can't exceed 8%. And then the next question is, would the pet fees, water, unpaid rent? A lot of leases say that any payment is going to go towards the last, or the oldest debt first. So a landlord could argue that it's always just, oh, you're short on rent this month, so you're actually paying a late fee for the January lateness now, not from the December. It gets a little bit slippery. And if I'm a landlord attorney and I was advising my client, I'd be saying, look, charge a late fee once and never duplicate it, would be my basic advice based on how the statute is written.
All right. Okay. Kimberly is asking, we have a tenant who wants to stay, but their co-signer wants to terminate. They were approved based off the co-signer being the one who has income.
Okay, so co-signers we see typically in college areas. That's the most common spot we'd see that. Usually mom or dad is signed with the kid saying, hey, look, landlord, if the kid doesn't pay their rent, then I'm good for it, right? That's sort of the most common version of a co-signer agreement that we see in Minnesota. That's not all of them, but that's most of them. And typically those leases are 1-year deals. After the year, the tenant is trying to decide whether to stick around or not. And I have seen landlords in the past try to unilaterally keep the co-signer obligated to that first year's lease, which may or may not be possible depending on how it was worded. But if the co-signer wants out, I don't think there's much of anything the landlord can do to stop the co-signer from taking themselves off the contract at the end of that contract. Now, midway through the contract, that's a different question. The co-signer can't run away from a contract they've signed in the middle of that contract. But at the end of the contract, assuming that the co-signer is giving the right amount of notice, yeah, the co-signer can say, I want off of this lease. Not much the landlord can do to stop them from getting off the lease. You might think as a landlord, okay, well then I can just give a notice to vacate or a notice of termination of the tenancy to the tenant at that point, which is normally true. A couple exceptions to that. Number one, St. Paul is going to have an ordinance starting on March 1 that has a just cause requirement. And I'll be honest, I don't remember if that would fit into one of the exceptions or not. It's been a while since I've looked at that ordinance and it's not in effect yet. So it's not really something we're spending a lot of time working on. If we're still giving presentations like this in March, we'll definitely spend some time talking about the St. Paul ordinances, including their just cause ordinance, the first in the state. The other problem that a landlord would have with giving a notice to terminate a tenancy right now would be the governor's, eviction moratorium, which doesn't just stop evictions. It also stops terminations of tenancies or notices of termination. So landlords' options are fairly limited here. I don't think there's any way to force the co-signer to stay on the lease if it's, like I said, at the end of the contract and they've given proper notice.
All right.
It's an interesting question, though.
All right. Next question. An unmarried couple, lease expired and rolled to month. He kicked her out. Landlord will not remove her from the lease due to financial responsibilities. He doesn't want to move until summer. Since she is on lease and responsible legally, can he keep her from the household? No illegal activity happening.
Okay. All right. So again, we have, I think, 4 questions in line. This is one of them. And we have about 25 minutes to go. Please feel free to submit your questions. They tend to all come in at 2:55 is when we seem to get a rush of questions. So the further in advance you can get them to us, the more likely it is that we'll be able to answer your question. But let's start with this one. All right, so we have an unmarried couple. The lease has expired. Now we're month to month. He kicked her out. So of the two tenants, he kicked her out. The landlord will not remove her from the lease due to financial responsibilities. And he doesn't want to move till summer. She's on the lease, responsible legally. Can the guy keep her out of the place? I'm not sure how. I'm not sure how that the guy tenant could keep the female tenant out of the rental unit here. She's obligated to pay, it sounds like. I don't know why her right to possess would end. In general, tenants that are on a lease together, neither one has a superior title or claim to possession over the other one. Now, there can be exceptions to that. If one got a restraining order, an order for protection, something like that, then they might be able to bar that person from coming. There likewise could be an agreement. And here, it might be an agreement that everybody in theory could want. Hard to know. I guess the landlord doesn't want it, because what we have when we have a lease like this is it's a three-party contract, right? We have the landlord, we have him and her. That's who we've got. So if anybody wants to change the contract, that's fine. But all three parties, both the landlord and the male and the female tenant, all have veto power over any changes to the contract. So a fair question here is, what right did he have to remove her from the place? Did he have really that power to do so? Now, she could willingly go. He could ask her to leave and she could simply vacate. But as far as enforcing rights here, that's a really different question. I'm not sure what right he had to remove her at all. And so I don't know why he'd be able to keep her from coming back in.
All right. Okay, next question from Dan. We're seeing a number of landlords issuing rent increase letters this past month to tenants who are currently already on standard leases with fixed start and end dates, not a month to month. We have not seen this before. Is it legal to raise the rent in the middle of a lease agreement?
It's a good question, Dan. To start, over the last 9 months, we've seen all kinds of things we haven't seen before. So this is just another one of those. And I can't say that this is a common thing we're seeing, but we are seeing it some now on our tenant hotline, where again, we get about 14, 15,000 calls a year. So we hear from a lot of people all around the state. About a quarter of our tenants tend to call from outside of the 7-county metro. So again, all around the state. But yeah, we've seen this where landlords are trying to raise the rent in the middle of the contract. Short answer is I don't see how they can do it. Now, sometimes a lease will say that the lease can be changed as long as the landlord gives a notice to the tenant, maybe a 30-day notice in the middle of the contract, and the landlord has the right to change the lease, which is always just sort of kind of a mystifying, in my mind, lease clause. I don't know what a landlord is expecting a judge would enforce with a clause like that. Because that's really what matters about all of these kinds of questions. It's not what I think or a lawyer that works for landlords thinks. It's what a judge is likely to think. And so a judge is going to start with one basic thing every time there's a landlord-tenant case, and that is, what was the agreement originally? Whether it's a piece of paper that looks really official like a lease, whether it's a cocktail napkin, whether it's a handshake, what was the agreement? And they'll always start with the agreement. So in Dan's situation, what I'm guessing we're hearing about here is that we have a lease that ran from June to June. Most leases end in the summer. That's when landlords want them to end. So June 2020 to June 2021. And right now, the landlord has decided, wow, things aren't going great for me, so I'm going to raise the rent from $1,000 to $1,100 a month. Okay, well, why? It says in my lease that I have the right to change the lease upon, notice. Okay, interesting theory, but let's just change the facts slightly from where we are today. Let's take away the price gouging limitation, something we haven't talked about much on these shows because it doesn't come up all that much. But right now, it's illegal for a landlord to raise the rent over 20% over the number that it was, I think, back in February of 2020. There's a price gouging limit. That price gouging rule was passed. I'm sure we all remember the great toilet paper scare of 2020. But there was a real concern that things like toilet paper and food merchants were going to start to spike the prices and more or less make it it could go to the highest bidder sort of thing. So the governor had a price gouging rule put into place with really substantial penalties built in. And it covered all kinds of things, including food, but also things like housing. So it limits rent increases to 20%. And I think that's still the rule going forward. But let's say that was gone for a second. And the tenant is in the middle of a 1-year lease and the rent is $1,000. If that price gouging statute or executive order isn't in place, there's nothing stopping legally a landlord from raising the rent from $1,000 a month to $1 million a month, which is just absurd, right? Go from $1,000 to $1 million a month. No way it's worth that market-wise. But the tenant is still locked into this lease. They've got 6-7 months to go. But the landlord has raised the rent to $1 million, right? Now, that again, I know how absurd that sounds, but the only difference between that and a landlord going from 1,000 to 1,100 is the amount. That's the only difference. On a real fundamental level, a lease has 4 pillars. And we talked about this in prior sessions, but I don't mind bringing it up again. There's 4 key components to every lease. Who are the parties? Who's the landlord? Who's the tenant? What's the property? We're talking the address, maybe the apartment number, right? How long is the lease for? The duration of the lease. Is it a 1-year lease? Is it month to month? And the last part is price. Now, I've seen leases that are 50 pages long, but they really are built on those 4 pillars, right? And the price is one of the key pillars. And if you want to change the price in the middle of the contract, you better have some extraordinary lease language that allows it. And even then, it might not be enough. It depends on how it's written. But a landlord just unilaterally deciding to increase the rent in the middle of the contract, I'm going to default to say that's probably not something a judge is going to enforce, although I'd still need to see the actual documents. And I'd be happy to look if you wanted to have your, if you're the tenant, Dan, or if you wanted to have the tenant that you're working with contact us on their behalf.
All right. I'm going to jump in here with the question that came in the chat from Jake. Does the law say it doesn't apply where there isn't a state level moratorium? Would the federal law terms apply and supersede the state moratorium if the state provides less protection? So that's, I guess, the CDC. The CDC, does it apply where there's not? Yeah.
Yeah. Okay. I don't remember what the CDC, I'm sorry, the CARES Act legislation might have said about deferring to the state level moratorium. Although I read the CARES Act only 9 months ago. 9 months ago feels like 9 years in pretty much everybody's mind these days. But the CDC moratorium, the one that we really care about right now, explicitly steps back if there's a state moratorium that has more protection for tenants. So it's a good question, Jake, but the CDC language explicitly, very clearly says if there's a local, so it's not just states, some cities have passed eviction moratoriums, and I think some counties around the country. So if there's a local or state ordinance or executive order or statute that is more protective of tenants, then that takes priority over the CDC moratorium. It's a good question, but it is answered explicitly in the CDC executive order language.
Yeah. All right. Then there's a question from Tina. There's a lot of apartments being built in Minnesota, but the rent is too high for some families or individuals to afford. Do you know if there's subsidy space available for these newer buildings? Are there any buildings being built for low income people?
That one's more yours than mine, Eric. Go ahead.
Yeah. Well, I think at the end of the year, the Minnesota Housing Finance Agency announced, when was it? Yeah, it was, I think, at the end of the year. Let's see the news release. I'm trying to look it up. Yeah, it was in December, late December. They announced $195 million going towards the creation and preservation of over 2,300 homes. So that includes rental units and single family homes too. So, there is, it's a good question. There are definitely a lot of apartments being built. There's plenty that are entirely market rate or even luxury focused. Some of those, I think and we had Dan Hilton from Housing Link on one of our webinars last year. And I think maybe we should have him come back because it's been a number of months now. They were monitoring sort of the trends in vacancy rates and rent levels, and there hadn't been, that was sort of earlier on, maybe it was midsummer, I can't remember, but
yeah, Yeah,
They
I
had
think that's
just
right.
started to, some of the data they had was just starting to show a slight shift in the rental market, influenced by potentially by COVID. But yeah, I think there are avenues where there is subsidy going into rental units. It's not enough. That's 2,000, nearly 2,400 homes does sound like a lot, but in the grand scheme of things, when you've got many low-income renters already overburdened with rent amounts, there's just a great need for putting those folks into affordable units and creating more for new residents needing a more affordable homes. So I'm not sure if that's a good enough answer, but I'll put a link in the chat to the information about Minnesota Housing approving new units. Again, some of those are preservation, so they're units getting preserved that had long-term subsidies and that are going to retain affordability, and then some of them are new units that'll be built, and so they won't be ready for tenants for months at this point. But it's sort of a constant struggle to get more subsidy and funding towards these programs. So point well taken. All right, and then another question: does Homeline have an opinion on sweeping of camps by cities as being illegal eviction if everyone having housing must be guaranteed by the state in a pandemic?
To start, this is the last question I think we have submitted. We still have about 10 minutes to go. So if you have another question, landlord-tenant law, certainly COVID related, or if it's not COVID related, that's fine as well. Make sure you submit it. I'll be honest, I don't have much of an opinion on this. And I realize that maybe I should, but the last 9 months, it's been trying to keep current on all the rules on the issues that we are, considered an authority on, which is landlord-tenant law in the state of Minnesota. This isn't really a landlord-tenant law question. I'm not saying it doesn't matter. It's just not the stuff that we focus on. I'm not sure how much of the policy level policymakers you've had a chance to hear from on this, Eric.
Sorry, I was looking at something else. I don't know. I don't really have. There's. I'm not sure if there is sort of some edict that says everyone must have housing or it must be guaranteed by the state. I'm not sure that that's been formally adopted by anyone, unfortunately. And I think for the most part, the eviction, suspension, and then other related like stay-at-home orders have been specific about that it does give some flexibility and allowance for law enforcement to break up camps when there's a determination of safety issues. So yeah, for the time being, it's not. I don't know if we have an official opinion. I think we don't like the fact that there are camps and that there's not enough housing for everyone at any time, but particularly during a pandemic, and the breaking up of those camps could definitely influence and increase the chance of the spread of COVID and worse things. But for the time being, there has not been any sort of action, I don't think, by either through executive order or by the legislature to like sort of create that broader guarantee of shelter during the pandemic. There has been, I do know, and this is not really in our wheelhouse entirely, just focused on tenant landlord law. But I think one thing to mention is that there has been an effort in a number of counties to put CARES Act dollars and so, Mike did talk about the CARES Act and how, for the most part, that's kind of a distant memory, but it's not entirely a distant memory for the fact that there still is a lot of CARES Act dollars that were used right up until the end of last year for a number of things like rental assistance. And some counties did put money towards the purchase of and funding for hotels and other forms of shelter for people that were unhoused. So there, and I'm not sure if, you know, so some of that has gone towards those efforts. I'm not sure how, if or how the new rental assistance pot of funds that's coming to Minnesota would impact that. My understanding is that it's more strict than the CARES Act dollars were in terms of what it can be put towards, that it has to be specific for rent, but that it is, there are some avenues in which it will be helpful for those relationships. So sorry if that's not adequately answering the question, but that's what I have to add, I guess.
And Eric, one thing we didn't talk about with Kim Tennyson's speech on the 27th, I assume we'll be applying for CLE credits for that?
I don't know. You know, we weren't going to have it be a formal presentation. I thought it was.
Oh,
gonna
that's
be
right.
more,
It was just going to be more of a Q&A. Yeah.
Yeah. So,
Okay.
yeah. So I'll put up. Let me see if I can put that up again. I don't. There's no other questions that have come in. Have there?
I don't see any open questions anywhere. No.
Okay. Well, so I guess we can get close to calling it a day if I can get my screen to work here. And just, oops, maybe I should just give up on trying to do this. Well, I did put a link in the chat to there we go, to the registration for the 27th, but I'll do it again. And just a reminder that, yeah, we'll have landlord attorney Kim Tennyson, who joined us at one point last year, on to sort of share some perspective from that point of view and answer questions. And then again, we don't have the registration set up or everything totally finalized yet, but then the session after January 27th will be on February 10th, and we'll be joined by a number of legal aid attorneys from greater Minnesota communities to share a perspective outside the metro area. So
no speech next week, no speech the week after that, which is inauguration week. But then we have one the 27th, and then again February 10th. So every 2 weeks, it looks like after that.
That's right.
Okay.
Okay. Well, we'll thanks for joining us today, and now you can sign off and go read the news, because there's plenty to read about. Thanks, everybody. Have a good day.